I thought this was just worth mentioning for a quick little video. It's a section out of one of the 1837 Acts, and I just thought I'd read this to you because it's quite interesting when we're looking at the Attorney General and their functions, but also when we're looking at the right to petition, but also other law as well, like criminal cases. But anyway, just check what you think to this, right? It says, "And it be enacted that it shall be lawful for any three registered electors." So it's talking politically now about registered electors to complain by summary petition. So it uses the word petition with a descriptive of, like, if you're having a summary charge, right? But also the electors who are bringing it, right? Registered voters. So summary petition either to the Court of Session or the Sheriff of the county. Well, that would be like the police chief, right? Or the Court of Session. Against any person for a breach of any of the regulations imposed by virtue of this Act, or the enforcement of the performance of the duties or observances, or the payment of any of the penalties hereby prescribed or imposed, or to apply summarily to such court or sheriff as foresaid, for interdict against any wrong done or contemplated against such burgh or town or community or the property thereof, and the case, and in case no such complaint shall be made by the electors as foresaid, it shall be competent for the Lord Advocate of Scotland for the time being, when he shall consider it expedient for the public interest, to sue by summary application for the redress or punishment of any abuse or malversation or mismanagement which may conceive of taken place, and that either the Court of Sessions in his own name or through the Procurator Fiscal in the Sheriff Court, provided that every such complaint or application shall be lodged within 3 months of the date of the cause of the complaint, and that within 14 days thereafter the private parties of complaining shall have found caution to such amount the court sheriff may require for payment to the costs to which parties may eventually be subjected. It's looking like this is like also if the magistrates or the sheriff themselves or anyone working in the government doesn't follow the law, doesn't obey the law or comply with the law, which is what you can do if a council doesn't do something lawfully, but you usually have a judicial review. So it's a little bit like the judicial review in a way, but also it could be criminal. It could be illegal. Now, most of the time now, the majority of people who complain against councillors or police or anyone in the government who's broken the law and not followed the rules, we usually get ignored. But it's saying here that if you've got 3 registered electors, well, that's usually also, in law, they set it out that you can't even meant to bring charges against everyone without 2 credible witnesses, right? You actually need 2 credible witnesses. So it's like referring to your 2 credible witnesses, but saying that they're actually registered electors, kind of politically, by summary petition. So it's kind of really saying that you're doing a petition, which actually could be for wrongdoing, or, not following a rule or procedure, right? You're actually petitioning, it's the Court of Sessions or the sheriff, right? But you've got at least 3 witnesses, and you actually write a petition, and they've got to really take it to the Court of Session. And also, in case no such complaint shall be made by the electors as forsaid, it shall be committed for the Lord Advocate of Scotland for the time being, once considered expedient on the public interest. Well, you're showing public interest if you've got 3 electors who are registered who submit a summary petition. If the Lord Advocate does it, really, actually, such court or sheriff may be required for the payment of the costs which such parties may eventually be subjected. Well, if you win, and if you were right, you don't get subjected to any costs, do you? And if the Lord Advocate themselves acts in the public interest, then if the Lord Advocate noticed wrongdoing himself or someone told him about it and he acts in the public interest, then you're not charged with anything. So that's government. This is the thing. So with the local council, if they are like doing a redevelopment of a town centre and they break the law or break the rules, like I'm accusing them of false advertising, election propaganda, influencing the public through illegal adverts and giving entertainment unlawfully, which is entertainment that even influences the voters. They're even giving, some councils are putting radio shows out for entertainment called the Redevelopment Show, which is all actually influencing for pro-redevelopment, as if they're trying to get all the children on board with it and to go along with it, which is actually affecting them if they wanted to oppose it or even call the council out on doing something wrong. Well, it is wrong to influence the electors, so that's one thing that I found that is illegal. This is like on Rachel Reeves on her YouTube channel when it was declared as an MP, but she carried on putting adverts on there. Jacob Rees-Mogg on GB News. We now know that it's not just news programmes that they can't present, it's actually entertainment, because he's giving entertainment to his electors, right? Things like that as well. But it proves that this is why they've got to have the Electoral Commission and the Advertising Standards Authority and Ofcom and all these other departments, not just the Attorney General. But what I like about this is that the way it describes it, it's like when you're petitioning Parliament. It's like you're an elector, a registered an elector. There's 3 of you, so you've got 2 credible witnesses, and it's regarded as a summary petition. And you submit it to the police or the Court of Sessions. And if you don't submit it, but the Lord Advocate is made aware of it or someone reports it to him and it's correct, he can initiate himself, which is basically like the Attorney General now, Richard Hermer, right? He's saying that he does contempt cases. Well, it might not just be us in contempt of court. It could actually be the government or the council or anyone breaking rules or laws, right? And the government can cover the costs as well if they initiate it. But if you initiate it and you are wrong in your claim, you've got to pay the costs. But if you initiate it and you're correct in your claims, then you don't have to pay the costs. But if you report it to the Attorney General, really, I don't think many people are actually... What I don't think is happening at the moment is, I don't think when somebody complains to the Attorney General, they're getting, like, actual other people to sign it as witnesses and writing it out as an affidavit. And that's the thing. I have actually submitted a proper petition with like 500,000 signatures to the Attorney General. And I wanted to as well just show you this. I wanted to compare this, right? So this is from the same act I've just shown you. And these are like the oaths and the affirmations or the little... So this is the manner and form. This is like the layout of how you've got to submit a crime to the sheriff, right? It says, right? Oh, hold on a second. This is for the election. Wait. Right, so this, right? This is a little oath for actual people who are going to vote. And I would say that even though they don't have these oaths anymore, it's still the same principle in the Representation of the People Act. But this just gives you a lot of insight into it, right? And this says that, it says, I do solemnly swear or affirm that I have not received or had by myself or any person for my use or benefit any sum or sums of money or an office, a place of employment, a gift or reward, so a gift, that's important, we'll come back to that in a minute, or any promise of security or any money, office, place or employment or gift or reward in order to give my vote at this election. That's very similar to the original American Constitution, when actually the people who were working in government in office didn't actually vote because they're meant to be impartial. So when you go to vote, it's minus all the people who work for government or in office, right? And obviously there's different counties have different numbers of people and they're separated into different divisions. So there was a different number of polling stations and number of voters in every state. But this is important insight. Now, this gift or reward, it turns out, what does it even mean? Well, if you actually look in 1688, in some acts that are passed around the same time as the Bill of Rights, there are actually some acts about voting. And it does actually say that they're not allowed to it's not just buying you gifts or buy you a hot dog or buy you a pint if you vote for them. It says that if they provide entertainment for votes. Now, I think that this is Jacob Rees-Mogg on GB News, right? Because I think that Mogg is an entertainer on GB News and he's being paid to entertain people in current affairs programmes. It's a form of entertainment. And it's not just the fact that he can't be a news presenter. He can't actually be any presenter at all because he's being paid by a TV station to entertain people in current affairs shows. So that's also the electors in his area. So the love of social media has really carried these people away and caught up with them and overtaken them, and they really have ended up breaking the law now, I think. And I've noticed that many local councils now, I knew our council were doing it because they went overboard with advertising, trying to push this town centre redevelopment as this blueprint, and they really put, the entire town was all, it was effectively adverts which were all heavily pro-development and giving the impression that they were going to redevelop it whether we liked it or not, and it was inevitable and make it look like everyone supported it. Even at the stage when they were still taking consultations and people could still petition against it, and maybe even votes in the chamber hadn't been done and people could still do representations either way. So what they're doing is they're making it look like we're doing this no matter what, and that's an influence. That is an influence advert. And now I've noticed loads of councils on social media, on Facebook, are just doing all kinds of things like, oh, this is like really cool commercial radio style little radio shows with cool modern trendy presenters, but they call it the Urban Redevelopment Show, like as if there isn't an alternative like show they're giving for not redeveloping, right? So it's all designed to make the public think that everyone wants it and it's cool and trendy and there's no other alternative, and that is actually influencing the electors. And it's just at your fingertips. It's so at their fingertips now. It's like them having drugs in front of them, and they can't, say no to them. They can't, or cigarette, and they can't stop smoking, or they can't stop eating biscuits or whatever. They're just, social media, this is cool. We want to be a cool, trendy council, but they're breaking the law, particularly when it comes to council decisions and opposition and voting and so forth. And actually, this includes Rachel Reeves and Rees-Mogg as well, and other MPs, maybe even Farage or Tice, you know, and George Galloway, at least when he was in office, but he wasn't in for that long. He said he prefers just being having a media show rather than being in government, because you get more influence, and that's the point. They're having actually more influence than if they're actually an MP, some of them. But anyway, and the last point, I wanted to do this in a separate video. So here, this is in the Act of Law in the schedule, right? Now, what it's got in this schedule is it calls it a complaint. This is your affidavit. This is it. When you go to a police station now, right, even when you report to a police, you normally just ring them up and speak to them on the telephone or send them an email or a letter. If you actually get police coming and taking statements, or you've ever been to a police station and given a statement, you have to fill forms in, then afterwards, the police are the ones who fill in what you call is the actual affidavit to the court, which gives them lawful right to pursue criminals. They've got certain powers to do things on suspicion there and then without putting anything in writing, but like for those dispersal orders, section 42, you've got to put it in writing and serve it and so forth. Senior officer and warrants, they've got to get from the court. Now, this is the thing. When you had the local townsfolk and someone committed a crime, and you've got hue and cry, where actually everyone in the village has to apprehend them, or they get fined. If the village don't apprehend the criminal, they actually get fined. So everyone's a police officer. Now, in order to lodge the complaint and make it official, that everyone therefore has a legal, lawful right to apprehend that criminal, and when they do apprehend that criminal, it will be policing. You're acting under as a special, a voluntary police, right? When you do that action. So when you go to the sheriff, you've got to go to the sheriff and give them this thing, which is basically a petition. But you call it a complaint, right? And just for example here, right? So it's saying, right, unto the magistrates of the borough or town of the complaint of, that's your name there, AB, procurator fiscal of the said borough or other party with his concurrence. And now these words are very important. It says here, humbly showeth, right? Humbly showeth. This is really important in the form of this. You're actually giving evidence. This is you're laying informations, you're laying evidence, right? That CD, that is the accused or the respondent or the person who's been accused or complained of, could even be the mayor or could even be the sheriff or the magistrate you're complaining against, right? Or the councillor or a member of parliament. The CD has been guilty of the crime or offence, which you enter there in brackets, that's where you write, fill it in yourself, of theft or other crime or offence, actor or art and part, insofar as here state the particulars of the crime or offence, specifying as nearly as may be time and place where it was committed, and also specifying that the money or the value of the article stolen, resetted or obtained by falsehood, fraud or wilful imposition, where these crimes are charged, did not exceed £10. Well, that is because this is for, I think this is a summary offence. It's not a serious offence, because if it was serious, then it would be going to the assizes and it would be an indictment, and they might be ending up in the gaol if they get apprehended and have to wait a month or two for the assizes to come round, if it's serious crime. May it therefore please your honours, this is important form here, take note of this form. May it therefore please your honours to grant warrant to apprehend the said CD and bring him before you, or to cite him to appear before you and answer to this complaint, and hereby to specify what is concluded. So this is warrant to apprehend him and bring him to you. So this is not even like the police can just arrest someone, right? Like, say the police is walking through the middle of Manchester, right? And someone steals something, they arrest them and they take them to the police station, right? For questioning. They haven't been and gotten a warrant from the magistrate or sheriff, right? According to justice. You get this signed off, then if you see the criminal, you can apprehend him, right? Obviously using reasonable force, or maybe even kicking the door down or whatever, right? When you get this submitted and signed, or, whatever. And then you've got this granting warrants to officers of the court to apprehend them before designed CD and bring him, repeat, or you can bring him or cite him to appear or answer to the foregoing complaint on the day of. So this is like bail, right? If you apprehend him, if it's not an indictment and he's not going to the assizes that are coming round, if it's just like summary, they can just say to him to appear. He's got to go to court, which might be at the local 100. And I think they actually had the councillors, or I'm not sure if you just have the magistrates or if those. If you look at the William Penn trial, you've got the alderman there, the 5 or 6 councillors and recorder, which is odd because it's the assizes and not the 100 court. But it gives you an idea of how the criminal and civil and council business was a lot more less divided then. And really, it is just a court, the local council, but they don't do criminal or tort cases anymore, but it really kind of is. And the councillors are a lot more of them because there's a lot more areas, so they've got a lot more councillors or aldermen. Procedure. Comprehend the said C&D and the complaint being read over to him. He answers that. So there's also one of these for a little postius as well. Now, I just want to compare this, right? So the words, therefore may it please your honours, and then this humbly showeth part, right? So this is a petition to the House of Commons. Like when we now go on and log on to the Petitions Committee in Parliament, right? This is Edward Vaudrey. This is rare because it's one of the surviving petitions from the House of Commons, which burned down. The House of Commons burned down, the Great Fire in 1839 or around that time. And they're reckoning that all these got burned, except the ones that are in the Sessions Books of Parliament and got read out. All the other ones have been lost. So they're saying. But see at the form here, to the Honourable Knights, Burgesses and Citizens, the most high, I put underline here, high and honourable Commons of the Parliament, the humble petition of Edward Vaudrey, showeth, there. So there it says showeth, so this is